Okay, shall we move on to the next big one, which I know people are talking about, the Second Amendment decision coming out of California?
Sure. So the great ruling, the judge is a Cubano, and I think that's partially why he was also the one that struck down the earlier ruling that's now pending en banc before the Ninth Circuit on California's rules regarding certain kinds of ammunition. So, he's a very knowledgeable gun judge. That's quite evident, appointed by W, senior judge. So that means he kind of gets to take what he wants to take to a certain degree because he's no longer on active duty in the same sense as a regular judge. And clearly, and he issued a very thorough decision after a bench trial, 94-page ruling that went into extensive detail that showed that under any legal standard of analysis, it's probably the best, if you want to understand gun rights issues in America from either perspective, reading his decision is a good way to get there because he'll give you both the evidentiary and legal roadmap of what the different issues are because he applies it under ultimate scrutiny, strict scrutiny, and intermediate scrutiny, applies it under the various alternatives that could have existed. The simple problem for California is the same problem that liberals that support gun control find when they do data analysis, which is there's very little evidence supporting most gun control laws. And so what the California state legislature did is they just didn't make any findings. And that's what backfired on him. There was no extensive hearings. There were no details. And that the judge took huge advantage of that in his ruling. So basically he said that, they banned the AR-15 is banned in California, for folks who don't know.
And
as a quote,
for folks who don't know, it stands for Armalite rifle and not assault rifle. I think that's one of the common misconceptions out there, but just to throw that out. Sorry, Robert.
The word assault rifle didn't exist in political lexicon until the late 1980s. It was a smart made up political term on the left to try to restrict Second Amendment rights in the country because that sounds scary. Most people think, machine guns and Uzis, and this was during the time of drive-bys in the 80s. And, the last time we'd had major gun control was the 1920s when, Machine Gun Kelly and those folks were out, doing things, and the Valentine's Massacre in Chicago, those kind of events. And so it was playing off of the drive-by shootings with automatic weapons in the 80s was the pretext for assault weapon bans. Now, the problem is a gun like the AR-15, assault weapons kind of is a made-up term. It's not really rooted in the guns itself. It's just a legally, politically superimposed term. So that's problem one, because then you don't really have a close evidentiary connection between an actual gun. Then the second problem is what they really targeted were guns that were uniquely accurate and very effective. In other words, the more effective the gun was, quick and accurate, the more they called it dangerous and thus tried to ban it. But the judge's point is that's precisely what makes it a very effective self-defense weapon. Is you're more likely to be accurate. In other words, not hit the bad guy, not hit the wrong person, and you're more likely to be able to be quickly effective if you're, say, 3 people are raiding your house. And as he details, there's been over 1 million burglaries a year in the United States, home burglaries. And so it's not like it's an unheard of, unprecedented, unparalleled phenomenon. And so in that context, and now he started off with aggressive language meant to frame the debate. And it's going to be controversial, but I think it's successful. So like I had a recent debate where I used a particular term, and my goal was to get other people to repeat it again and again and again and again and again.
Well, there's someone in the chat. I've noticed it every 20 seconds.
Exactly. And I want to thank them. You're using my term. He who defines the term wins the debate. So keep using the term. The fact they think it's sardonic or critical is even more self-ironic. But the and so I think that's why he chose the language. He wanted them to reconceptualize the debate to the question is this particularly useful as a defense mechanism? And so he started off with language that's going to enrage the left, because his opening sentence was, like a Swiss Army knife, the AR-15 is particularly good both for home defense and homeland defense. This is only a Cuban judge would have this kind of aggressivity. They have a certain acerbic wit that's born of that life experience and everything related to it, and escaping Cuba. And it's why they're very strong on these issues. In my experience, Cuban judges have been way above average. Not always the best defense judges to have, but definitely way above average otherwise in constitutional ability and political under practicality. So, but what he just details is that this gun is particularly effective for home defense. That means it's within the Second. The other thing he did, which was for me fantastic, the point that I've been trying to hammer away at is that Second Amendment's about home. It's about self-defense. That's what it's about, particularly self-defense within the home, but not only self-defense within the home. And he says that about a dozen times. He says this is about self-defense, 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 self-defense. So if this is a particular means of self-defense that best protects self-defense, then it has to at least meet strict scrutiny. And he's like, it doesn't. The three levels of scrutiny are if it takes away core Second Amendment rights, then it's struck down, period. There's no deference given to the government. If it simply imposes on something that is the core issue that's being protected, then it's strict scrutiny. Then they have this ridiculous standard, but they call it intermediate scrutiny, which is just watered down. And here the judge does a great job describing how bad intermediate scrutiny analysis tends to devolve into. My view, court should scrap it, just go to strict scrutiny, and that's it. Don't have any lower than strict scrutiny. Maybe rational basis, but that's another crackpot waiting to happen. But he just details it in excellent detail that it doesn't meet the highest level of scrutiny, obviously, doesn't meet strict scrutiny. And he points out it doesn't meet intermediate scrutiny because the legislature didn't create the evidentiary findings necessary to say, why is this gun particularly likely to be used in a criminal way and not likely to be helpful for either self-defense or militia use? And in fact, their main argument was an argument that highlighted how effective it would be for self-defense or militia use, the two interests protected by the Second Amendment. So now the Ninth Circuit, who knows? It's going to, whether this gets affirmed will really be what the Supreme Court does in the other gun cases pending before it this term.
All right. And if for anybody who may not know the backdrop, bottom line, in a nutshell, 32-year-old piece of legislation that places certain limitations on three aspects of firearms. I couldn't get into them because I don't understand anything about it. I just know the words on a paper, but something to do with the way that they are tailored, the grips, the capacity of the magazines. So this 30-some-odd-year-old law, which effectively banned, if it's not the AR itself, it's certain modalities or certain functions on it. Apparently, I guess it had never been contested before, or challenged, I should say. And it was challenged. And like you say, Robert, it's an interesting thing. I didn't get into the weeds of the decision, but the judge did basically say in a critical way, there was no history of the legislation. There was no evidence presented at the time. So I have nothing to look at now, talking about the 14,000 pages of evidence and statistics. But yeah, so he goes into the statistics says, knife violence versus long arm or long arm violence, hands and feet and bludgeoning and, other objects versus rifle violence. And people confound a lot of statistics in the debate. I've seen it. I've learned it. One of the main statistics people confound in gun violence, in quotes, is including suicides. And then the other thing they sort of confound to inflate statistics is gun violence versus handgun versus firearm. So this judge did a good job breaking down the points, which were not all firearm violence, not all forms of firearm violence, specific to what was being challenged, and concluded it didn't meet the required burden to justify the violation. Yes, the opening paragraph were pure fighting words, like a Swiss Army knife. It's good for defense and in battle. I forget exactly the terms, but I said, he did it in a way that was going to trigger response. It got the media covering it with certain angles, and it got Gavin Newsom coming out. But so one of the things I didn't mention is that so it's going to not an appeal, but I think it's going to a panel of 3 judges. This decision right now, there's no outright appeal, or has it already gone to appeal?
No, it'll be going to appeal. He stayed it for 30 days so that they could request a stay from the Court of Appeals, and he gave the Court of Appeals 30 days to grant the stay. If the Court of Appeals does not, then it will go into force. And so then it will go on appeal anyway. But it will be so my guess, if the Ninth Circuit doesn't like it, they'll issue a stay. If they do like it, then they will not grant a stay, and then it'll be probably 6 months to 9 months. But the Ninth Circuit en banc is handling another case that came up from him that was on like bump stocks and other things like that. And so in a sort of not as a well, where the arguments are even stronger on his side. So if the en banc decision reverses him on that, then they'll reverse him on this. If they don't reverse him on that, they're not likely to reverse him on this. But he has created, like Stickman did in the COVID context, he properly shifted the burden of proof to the state to prove why they had met their scrutiny. The state kept saying, no, they have to disprove us. And his point was that doesn't make any sense. If we're going to have any scrutiny of state actions, the state has to bear the burden of showing why this is rational, why this is reasonable, why this has a relationship to a particular legitimate state objective. And so I think he did a Stickman-like factual detail that's going to be hard for them to overturn without basically trying to reverse Heller and its progeny. So that's what this is really about.
Actually, that's the perfect segue. That was my next question. And I didn't mean that had it gone to appeal. I just thought a panel of 3 judges had already been appointed from something I read.
Not yet.
Maybe I'm mistaken. Okay. Heller.
And it's different. By the way, it's the panel that handles injunctions is a roving panel. They're not likely the panel that will handle the ultimate case.
Okay. And can you briefly explain for those who don't know what the Heller decision is and why it was so important?
Yeah. So before Heller, the Ninth Circuit in particular had said that there was no Second Amendment rights to self-defense, that there was no Second Amendment rights for an individual to own a gun, that an individual could not even sue, did not have standing to bring any claim on their restrictions on their Second Amendment rights because they didn't have any, according to the Ninth Circuit. So what Heller said is, no, all that's wrong. The Second Amendment is an individual right that gives you a right of self-defense by which the means of that right of self-defense is the right to bear arms and arms that would be effective for self-defense or the effective for militia use as an extension of collective public self-defense. And so that's what reversed the whole equation. And the Ninth Circuit has tried to whittle that down, and other federal courts have tried to whittle that down. That's why it was a big deal for the U.S. Supreme Court to take a case that I think will broadly expand the Second Amendment rights that will then lead to these cases being more like. I think that the Second Amendment is likely to hit its sunshine support, to hit its peak of support in the next decade.
Okay, fascinating. And I didn't actually bring up this chat. Can't wait for Runkle to bring Viva up to speed. Runkle is coming on Wednesday, Robert. That is our next sidebar. And I did want to say thank you to, I lost the chat. How can we challenge a law so late? There's no statute.
Because the law is still on the books and still effective. That's why. So if the law is not on the books, it doesn't matter. But or if it's not being enforced. But this law is being enforced every day in California. You can challenge that law anytime you want.
This was the first challenge.
Yeah, as far as I know, in federal court. But that was because when it was first passed, the Ninth Circuit said no individual could even bring a suit. That's why. So this is a post-Heller, and it was a good set of litigation brought by the Firearms Policy Coalition. It's doing really, really good work. I mean, frankly, the NRA and some other people should be more involved than they are, but that's another story. This is the group that's really bringing the best legal actions across the country on Second Amendment grounds.
Okay, and these are the chats here. I brought this one up. Gavin Cross, thank you very much. And Viva, you need to come down here to Oklahoma and let me take you to the gun range. First, let's have the borders open up first. Yeah,
I was going to say that's a good transition in the other Second Amendment case out of Pennsylvania. They tried to prohibit people from doing target practice in their own homes, outside their own. Basically, they blocked it. You could only go to select gun ranges in certain parts of the city, and that's it. You couldn't do target practice. The Pennsylvania Court of Appeals struck it down and said, look, target practice is critical to improving your accuracy. It's a core right of the Second Amendment, and completely banning it without any, in the whole communities under the guise of zoning laws was not at all, constitutional. Now, there was a judge who dissented, who was clearly one of these whiny liberal types, like guns are scary, scary, scary. One of those people. But guns are scarier when people don't practice accuracy. That's when guns are scary. They're not so scary if people know what they're doing with them.
Well, if we go by the statistics, they're also scary when people illegally possess them by and large, but that's getting into the debate and the actual statistics. But so, I mean, this one is new. I mean, I'm not totally familiar with this one, but they effectively, zoning laws banned people from using weapons on their own property in, I presume, indoors, outdoors, or was there any distinction? Just anywhere on your property?
Period. Outside of, it had to be in the act of self-defense or something like that. So in particular, they were trying to prohibit gun ranges and target practicing out back or anywhere that wasn't specially zoned for it in limited parts of the city. And and there are ways to limit problematic, people who are doing dumb stuff. There's nuisance laws that already apply to some of that stuff, but this was just complete. So, you could live on a 10-acre farm and couldn't, practice shooting in your backyard, in your very big backyard. So so it was another good Second Amendment, a lot of good Second Amendment decisions, because I think a lot of people correctly anticipate that the U.S. Supreme Court's about to give real teeth to the Second Amendment.
Amazing. The last Supreme Court decision was Heller. That was 2008. So,
well, there was a second one in 2010 that extended it, McDonald, that made it clear the Second Amendment applied to the states vis-a-vis the 14th Amendment.
Okay. And we got a chat here that says, from the ACLU website, the ACLU has long taken the position that the Second Amendment protects a collective right rather than an individual right. Any idea what this means? What's a collective right?
Look, it means just the state. That's what it means.
All that I know is, like, this has been, the Second Amendment issue has also been a massive learning curve and an interesting one, because yes, I in previous videos had used the term assault rifle because I'm quoting from, things, and people get upset. Viva, it's not a real term, yada, yada. I appreciate all that. I mean, I'm sometimes just reading from the actual judgments or the articles, but it's been a learning curve. And the Second Amendment and the history of the Second Amendment, living in a country now where the government and everybody thinks the only reason you need to own a firearm is for hunting. And this is literally things that our leaders have said. It was a very big learning curve to see what it means in the United States and what the history of the Second Amendment is. A well-regulated militia and the right to bear arms shall not be infringed. It has a reason. And I don't know what I don't know what that means. Sounds like it means that the individuals...
Only a state-approved militia had any rights, which made no sense, by the way, because that's just an extension of the state then. You don't need the Second Amendment. Completely redundant. That argument never made any sense. But, by the way, it's what the legislature did here that was problematic. They only looked at comparing the use of an AR-15 and similar guns in the context of recreation versus its use criminally. They didn't even look at the possibility of its use for self-defense, which the judge hammered away at.
I will not read this one out loud, but yes. No, it wasn't the ACLU. I get mixed up between the ACLU and the ADL. They both done questionable things. Okay, so the Pennsylvania decision 2-1. Does it go higher or?
It may. The Pennsylvania Supreme Court's very liberal, so we'll see what happens.